Now, huh? Okay. Chalo. Good evening, friends. I welcome you all, and thanks Anita ji for giving me this opportunity to use this platform to discuss the judgment, which is very, very fundamental to our legal knowledge. So before we start, let me begin with a question. Can Parliament amend the Constitution in such a manner that the Constitution ceases to remain the Constitution? Can democracy be taken over by the out of the Constitution by the Parliament? Can judicial review be removed? Can the rule of law be abolished? Can the federal character of India be destroyed by a constitutional amendment? I trust everyone will say no. So these are not merely academic questions, they go to the very heart of our constitutional democracy. And it was in answering precisely such questions that the Supreme Court of India evolved one of the most significant doctrine in constitutional jurisprudence, that is basic structure doctrine. From Shankari Prasad to Sajjan Singh, from Golaknath to Kesavananda Bharati, and thereafter through Indira Gandhi versus Rajnarayan, Minerva Mills, and I.R. Coelho and subsequent decisions, the Supreme Court gradually constructed a constitutional principle of extraordinary importance. The Constitution can be amended, but the basic identity cannot be destroyed. Today, therefore, we are not merely discussing a series of judgments. We are tracing the judicial journey through which the Supreme Court defined the limits of constitutional amendments and powers of the Parliament to amend the Constitution. That became the guardian of the Constitution's enduring identity. We are here to discuss summary of three judgments, that is Kesavananda Bharati, Minerva Mills, and I.R. Coelho, which are leading cases in the advocate on record examination. Before that, I would like all of us to know what were the situations that were prevailing post-independence, that is immediately after independence. On 26th of January 1950, our constitution came into effect, and wherein the fundamental rights were guaranteed under Part 3rd, Article 12 to 35, and directive principles of state policies were given under Part 4. The main role which I want all of us to understand is between interplay between Article 13 and 368. Article 13 of the Constitution says the laws which are inconsistent with or in derogation of the fundamental rights shall not be come into force. If I may say, if you are having a Constitution of India with you, you can pick that and we can see Article 13, whereas initially there were Article 13(1), 2, and 3. Clause 4 was inserted later on, which we will discuss at the time when I will discuss the amendments. We will be going in two parts. Today, I will only discuss the constitutional amendments. And these three judgments we will discuss in a second part. So, while at the time of post-independence, the government wanted to give equality to all the citizens. And for this, it was required that directive principle of state policies shall be given effect to, and thereby so many laws were formed. In this regard, the first change was made wherein state of Madras came out with a government order whereby some reservation was granted to the lower caste women. It was caste based basically. instead of merit, it was decided that admission in medical college be given based on caste, and some category was prescribed ki how many candidates from which caste will be given admitted in the medical college. That in fact affected the fundamental right of other one, the meritorious student who had better numbers than the person who was given reservation. So they approached to the Madras High Court, and Madras High Court held that fundamental rights cannot be violated, as it was challenged that right to equality has been violated by giving reservation to other person based on caste. So the state of Madras came to Supreme Court challenging order of Madras High Court, and Supreme Court upheld the judgment given by state of Madras. This was the case of Champakam Dorai Raju, the state of Madras versus Champakam Dorai Raju, wherein it was held that fundamental rights cannot be taken away. There were so many other cases also came in light whereby various high courts, in view of the fundamental rights guarantee, they upheld that fundamental rights will prevail over directive principle of state policies, the acts which have been made by the states. To overcome that, in 1951 itself, that is immediately within a year, the government came with first constitutional amendment, wherein the amendments were made. Article 15(4) was added, which says that nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and the scheduled tribes. Article 31A was also added with regard to acquisition of estates and management, as Jamindari Abolition Act was also there. The jamindars who were having acres of land, their lands were acquired, and it was policy of the government to give these lands to the poor farmers, so that they should also feel that they they are the citizens of this country, and they are getting what they thought they will get after independence. Article 13(1)(b) was also added, whereby Schedule 9 was inserted, giving immunity to law and act made by the government. Once they've been inserted in Schedule 9, they were made immune from judicial review. These amendments were challenged in Shankari Prasad versus Union of India. And the question which was raised was that Article 13(3), which includes every law which cannot come into force if it takes away fundamental rights. So it was said that Article 368, which gives power to the Parliament to amend the Constitution, is also governed by Article 13(3). But the Honorable Supreme Court has held that the Parliament has unfettered power to amend the Constitution, to bring social reforms, and they can change the Constitution without any limitation. In this went upon till 1964. The 17th Amendment came into force, wherein agrarian land reforms were made. The lands of the farmer were taken away who were having big lands, and a ceiling was imposed that any person cannot have more than this land in their possession, and the rest of the land were acquired compulsorily by the government. to distribute it to the others. The one case was of I.C. Golaknath versus State of Punjab, who challenged this 17th constitutional amendment. Before that, one in 1965, the Sajjan Singh versus State of Rajasthan the case was also there, wherein land agrarian reforms were challenged. But even in this case, whereby um, 5 bench judges sat, and with the decision of 3:2, they decided that Parliament has unfettered power to amend the constitution. But in this, Justice Mudholkar observed that there must be some control on the power of the government to amend the constitution. And he gave an idea of basic feature in this judgment. Justice Mudholkar and Justice Hidayatullah were in minority. Thereafter, in 1967, I.C. Golaknath, by filing Article 32 petition before Honorable Supreme Court, they challenged the 17th constitutional amendment. This case was heard by 11 judges, and the judges decided in the ratio of 6:5, and first time it was held that the Parliament has very limited power to amend the constitution, and Article 13(2) also involves the law that is under Article 368 constitutional amendment laws, and just CJI Subba Rao gave a doctrine of prospective overruling, so that the laws which were created previously, it should not be disturbed. To overcome from the effect of I.C. Golaknath, the government at that time, Mrs. Indira Gandhi was Prime Minister. So in 1970, Indira Gandhi came out with the bank nationalization scheme, where banks were acquired, but the compensation given to the persons who were at that time managing those banks were very meager. It was not just and fair. So that bank nationalization case which is with the name of R.C. Cooper versus Union of India, and known as bank nationalization case, is 1970. The Supreme Court held that compensation should be fair and just. It should not be a formality. In 1970, also, government came out with ordinance whereby privy purse sums of rulers were stopped, which was by issuing this ordinance. This was challenged by Madhavravji Scindia before the Honorable Supreme Court, and this ordinance was also quashed by the Honorable Supreme Court by saying that it cannot be done, as it is mentioned in the Constitution. Article 291 gives the immunity, and it's a charge on the consolidated funds of India. So, to overcome from the judgment of I.C. Golaknath, R.C. Cooper, and Privy Purse, that is the case filed by Madhavravji Scindia, the government again brought on 24th Amendment Act 1971, whereby they inserted Article 13(4) by saying that nothing in this article shall apply to amendment of this constitution made under Article 368. Likewise, Article 368(2) was also amended. It was added that President shall give his assent to the bill. It was added in that clause. Sub-Article 3 to Article 368 was inserted by saying that nothing in Article 13 shall apply to any amendment made under this article. These enabled all these uh, amendments enabled the parliament to dilute fundamental rights through amendments of the constitution and empowered the parliament to amend any provision of the constitution. And the next constitutional amendment, which was 25th amendment, to overcome from the judgment of R.C. Cooper, they changed word compensation with the word amount, because compensation could have include a just and fair amount, fair compensation, but amount could be anything. And the 26th amendment was to overcome from the judgment of Privy Purse, that is Madhav Ravji Scindia case, and whereby the government abolished the titles and special privilege, including privy purses of former rulers of princely states. 29th Amendment was of Kerala Land Reforms Act, which were inserted in ninth schedule of the Constitution. Thereafter comes the judgment of Kesavananda Bharati versus State of Kerala, 1973, wherein the Supreme Court reviewed the validity of the 24th, 25th, 26th, and 29th Amendments, overruling Golaknath while introducing the basic structure doctrine, holding that Article 368 does not empower Parliament to alter the Constitution's basic structure. The first part of Section 3 of the 25th Amendment was upheld, but the clause ousting the judicial review was struck down as invalid, preserving judicial scrutiny over laws claiming Article 39B and C protection. This hearing of Kesavananda Bharati went upon for about 68 days. This is the largest bench, that is 13 judges heard this matter. 7 judges were in favor and 6 were in minority. The majority was given by Justice C.J. Sikri, Justice Hegde, Justice Mukherjee, Justice Shellett, Justice Grover, Justice Jagmohan Reddy, and Justice Khanna. So, for about 32 days were taken by the government. 32 days were taken by the petitioner to argue the case. Then government also argued. And 1 minute. Sorry. As you must be aware that in 1975, because of this Rajnarayan case, emergency was imposed in India. In 1976, to overcome from this judgment of Kesavananda Bharati, 42nd Amendment was also came in effect, whereby the Am I audible?
Yes, ma'am.
Yes,
Okay.
yes.
So in Kesavananda Bharati case, the 24th, 25th, 29th amendments validity were challenged, and thereafter Kerala, sorry, I got disturbed. I was on this Kesavananda Bharati case was done away with, and to come out to overcome from this judgment, the government came out with 42nd Amendment in 1976, whereby Article 31C, Article 368(4) and 368(5) were inserted. So these articles are 31C was inserted, which says saving of laws giving effect to certain directive principles. And Article 368(4) and 5 were inserted, whereby it was the Parliament was made immune and power of judicial review was taken away. 368(4) says no amendment of this constitution, including the provisions of Part 3rd, made or purporting to have been made under this article, whether before or after the commencement of Section 55 of the Constitution 42nd Amendment Act, shall be called in question in any court on any ground. That means power of judicial review was taken away from the Supreme Court and High Court. For the and 368(5) was for the removal of doubts, it is hereby declared that there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation, or repeal the provisions of this Constitution under this article. Under these provisions, there were so many amendments were made by the government, whereby many acts which had no concern with the land reforms or agrarian reforms were also put in the ninth schedule. In 1980, management of Minerva Mills was taken over by National Textile Limited, and the petitioners challenged validity of Article 31B, 368(4) and 5 on the ground that it violates basic structure of the Constitution. The 42nd Amendment functioned as a calculated attempt to emasculate judicial oversight and concentrate constituent authority within the halls of Parliament, within the hands of Parliament. The petitioners then directed that their challenge towards Section 4 and 55 of the 42nd Constitutional Amendment Act. This case was decided by 5 judges bench, whereby it was decided with a majority of 4:1. The judges which were in minority in the Kesavananda Bharati, now they were in majority in this case. The 5 judges which formed the bench were Justice Y.V. Chandrachud, who were Chief Justice at that time, P.N. Bhagwati, Justice A.C. Gupta, Justice N.N. Utwalia, and Justice P.S. Kailasam. Justice P.N. Bhagwati was in minority. So it was held that Article 368(4) and 5 is unconstitutional as it damages the basic and essential features of the Constitution. Article 31C as well was held unconstitutional to the extent of changes made by 42nd Amendment Act, Section 4, and it was held that directive principles cannot have primacy over fundamental rights. Article 13, 32, and 226. It was held consideration of constitutionality of an amendment to the Constitution held permissible and not barred on ground of being academic or hypothetical when it permits legislative and executive action affecting fundamental right of the petitioners. In it was held that Kesavananda Bharati case has clearly stated that basic structure of the Constitution cannot be changed. And Article 368 does not enable Parliament to alter the basic structure or framework of the Constitution. Thereafter, the Kesavananda Bharati case was considered in so many judgments, but the government used to put all the acts which they enacted into ninth schedule, and thereafter the judgment in IR Coelho versus State of Tamil Nadu came, wherein the core issue was whether Parliament can use Article 31B and the 9th schedule to completely immunize laws from judicial review if those laws are found to violate the fundamental rights guaranteed under Part 3rd of the Indian Constitution. The court had to determine whether laws added to the 9th schedule on or after April 24, 1973, that is the date of the Kesavananda Bharati case, can be challenged on the ground that they damage or destroy the basic structure of the Constitution, and how the validity of such protected laws should be tested, given that placing a law in the 9th schedule effectively nullifies the application of Part 3rd fundamental right.
We have
Am I
10 more
visible?
minutes. We have 10 more.
Am I visible?
Yes, yes. We have 10 minutes.
Okay, okay. Wait. So the bench constituted was of 9 judges constitution bench. In this case, the unanimous decision of the court came. The court held that absolute constitutional immunity does not exist for any law added to the 9th schedule after the basic structure doctrine was propounded. The key rulings of the bench were that April 23, 90, April 24, 1973 is the cutoff date. So any law inserted into the 9th schedule on or after April 24, 1973 is open to challenge on the ground that it destroys or damages the basic structure of the Constitution. And there was the dual step test was there. To challenge a 9th schedule law, the court must first determine if the law in fact violates a fundamental right guaranteed under Part 3rd. If a violation is found, the court must then apply right test and the essence of the right test to see if the infraction destroys the basic structure. If it does, the law will be struck down. And second was the judicial review is inviolable. The power of judicial review under Article 32 and Article 226 is an essential and unalterable feature of the basic structure. Parliament cannot use Article 31B to oust the judiciary's role as the final arbiter of the constitutional limits. While IR Coelho itself was unanimous, that is, the 9-judge bench was assembled and they all were of the same view. But the IC Golaknath, there were a split judgment of 6:5, while Kesavananda Bharati was also split judgment by 7:6. So I think the judgments also been covered today. Right? So in case anyone wants to ask any question, they can ask.
Participants can unmute themselves and ask the question. Kapil Chafekar is asking Article 31C.
Yes. What he is saying? Article 31C?
Ji.
What he wants to know? Article 31C when it was inserted.
हाँ. Kapil, unmute yourself and you can ask, ma'am.
What is exactly Article 31C? What is the purpose?
It was to save the laws made by the government. What it was saying is that Article 13, which law is made, Article 13 is, if you read Article 13(3), it says any law included can be challenged if it violates the fundamental right. And 31C says, irrespective of whatever we'll create, and it won't come under article if it is violating the fundamental rights, even though it is valid. May I
Thank you,
read?
ma'am.
Notwithstanding anything contained in Article 13. Article 13 was giving us immunity that our fundamental rights cannot be violated by the state or by the central. But by inserting Article 31C, that immunity was taken away, which was given to us in Article 13(3). It says, notwithstanding anything contained in Article 13, no law giving effect to the policy of the state towards securing all or any of the principles laid down in Part 4 shall be deemed to be void on the ground that it is inconsistent with or takes away our rights conferred by Article 14 or Article 19, which are our fundamental rights. If that may be taken away, that means the government is giving themselves a power that they can take away our fundamental rights. Tomorrow it can be possible that they say that you have no right to equality. We can give uh, uh, any uh, any facility to any caste or any religion, and we can exclude you. So right of equality, which is there in Article 14 or Article 19, can be taken away or abridged. And thereafter, they also given power that no law containing a declaration that it is for giving such effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. So we cannot even challenge that law, which is taking away our fundamental right.
Thank you, ma'am.
अच्छा, कोई क्वेश्चन नहीं आए तो मुझे एक क्वेश्चन है, थोड़ा एनलाइटन कर दीजिए आप जुडिशियल रिव्यू पे। किसी का क्वेश्चन है तो पहले वो लेंगे, नहीं तो जुडिशियल रिव्यू पे मैम थोड़ा सा बोल देगी हमें, तो हम लोग सुन लेंगे, हमारे पास 3 मिनट और है।
Some chat is there.
नहीं, चैट में क्वेश्चन तो नहीं है। ठीक है किसी का तो अनम्यूट कर सकते हैं। जुडिशियल रिव्यू पे भी बोल दीजिए वंदना जी।
Judicial review is when government comes with some act or enactment ordinance whereby it can be challenged before High Court or Supreme Court. Judicial review is basically a legal technical term that is open to challenge. So what government did, they created ninth schedule and also stated that if we put that law in ninth schedule, it cannot be challenged by anyone before High Court or before Supreme Court. So even if it is a Draculian law, that could not have been challenged by anyone before High Court or Supreme Court. But the Supreme Court has held that this is the basic structure of the Constitution, judicial review, which gives Article 32 is the remedies, legal remedies which Constitution provide to us. So if it is taken away, that destroys the basic structure of the constitution.
Any more questions, please?
I will also advise all of you that in Supreme Court website, there are leading cases of every year. So you can go through those judgments as well. If aspirants are preparing for next year, it's better that they should keep themselves aware of all the judgments under the head of leading cases Supreme Court publishes on its website.
What Vandana ma'am today discuss is about the landmark judgments of the Supreme Court, and these judgments actually helped the development of the law and how the parliament runs in our country. So these are very important judgments. All of us should read, and as she rightly said, that these judgments are there on the Supreme Court website as well. We can
Not
guide you.
not those judgments, but the recent judgments as well, which are forming as they can be considered as leading cases.
Reading cases. So there are many judgments which comes every day, and right now we get lot of legal updates. But what is more important, these are the basic judgments or landmark celebrated or milestone judgment which we all should be aware. Kesavananda, D.K.